Hello everyone, Judicial Watch President Tom Fitton here with this special issue update, Election Integrity, the battle for free and fair elections. We have with us today a special guest, Judicial Watch Senior Attorney and Director of our Election Law Initiatives here at Judicial Watch, Bob Popper. I guess your full name is Robert Popper, but we call you Bob here. That's your nom de guerre. Thank you, as always, for your great work in this important area. I know a lot of you out there are concerned about free and fair elections. And Bob, I don't think there's anyone doing as much, practically speaking, in ensuring certainly that the voting rolls are clean, other than Judicial Watch. Over 2 million names removed from the rolls that we've had verified just in the last year, a little bit over a year. We've had verified as a result of our litigations and such. It really is remarkable, and I know I say that because it's Judicial Watch, I'm supposed to say that, but certainly by any objective measure, to have one group responsible for cleaning up all those rolls is something that is obviously a credit to Judicial Watch and its supporters, and really an indictment of the Justice Department. But how did we get these numbers to where they are?
Sure, it's something we take great pride in. It is something we're doing almost alone in the country, and it shouldn't be that way. Over the past 4 years, we have caused about 2 million, more than 2 million voter registrations to be removed from the voter rolls immediately because they are outdated, and they're recognized as outdated. Another 2 million registrations have started the process of being removed, where they get official notifications and there's a whole federal process.
So the likelihood is all those names will be removed too, or most of those names will be removed, like 95% plus.
Correct.
Yeah.
75 to 95% is our experience.
Yeah.
So that means something like 4 million registrations have been affected by our efforts in the past 4 years. Now, in November 2022, there are 110 million total ballots cast in the whole country. So 4 million is a lot. And we know that if we hadn't done what we've done, all of those registrations would be sitting undisturbed on voter rolls throughout the country.
So how is it we go about this process? I know, but I want you to explain it to our viewers here. It's the National Voter Registration Act, which is a federal law. And it's really quite simple, right?
It is simple.
In the sense of what the requirements are.
Once you understand what's going on, it is simple, in fact. What happens is that, of course, if someone dies, they need to be removed from the rolls immediately. That's part of the federal statute.
And that's state law requirement too, isn't
it? Common sense.
Yeah.
And if someone is barred by a disqualifying felony, and there are a few other circumstances, they need to be removed. But by far the biggest category of people who need to be removed from any state's voter rolls are people who've moved elsewhere. And usually they move elsewhere without telling the state. If they tell the state, that's fine.
So all those New Yorkers fleeing Florida, to Florida, are supposed to be removed.
Right, or let's put it this way. All those New Yorkers who go to Colorado and stay there for a couple of weeks and happen to register to vote and then leave, their names need to be removed. All those people who have a house in Florida but vote in New York, if they have registered for one reason or another in Florida, their names need to be removed. If you moved out of state 10 years ago, 15 years ago, your name needs to be removed from the voter rolls.
So it's kind of tough. Let's say someone moves away in the last 2 years. Mm-hmm. It's the government being the government. They have a little wiggle room, right? How's that wiggle room work?
Well, by federal law, they have a lot of wiggle room in terms of the time it takes to remove somebody. What happens is that the state suspects that they've moved, comes to believe that they've moved, and it sends them a federal notice letter. And all the notice letter says is, have you moved? Are we correct?
You didn't vote last time. Right. Where are you? We're worried.
Whatever reason they choose to send that letter is fine.
Yeah.
There's no federal restrictions. Once it gets sent, of course, if there's a response saying, no, we're here, that's the end of it.
Or if they vote.
And
that's like, so let's say I don't vote in the federal election in 2020.
Well,
What is the time frame before someone can actually remove me from the rolls, assuming they don't know where I am?
that part of the process is after the letter is sent. But
so I get the letter, I don't vote, they send the letter, you didn't vote last election. Are you still living where you are? Do you want to remain registered?
Right.
Let's say I ignore that letter, or I don't see it or respond. And then what else has to happen before I'm removed?
2 general federal elections. General elections, so not primaries, and federal elections have to transpire. And at that point, the federal law requires that that registration be removed from the rolls. So 2 general federal elections, if you think about it, can be almost 4 years or a little over 2 years. It's in that window.
Yeah, or as many as 5 years, practically speaking, if the timing's right, in terms of the letter going out quickly enough.
Well, you start to include the letter, and yes,
yeah,
it is a process that takes years.
So why on earth would our enemies on the left, because it's usually the left that opposes these efforts to take, and it's not a perfect, the rules don't have to be perfect, but you got to take these reasonable steps as you're describing,
Right.
object to waiting 4 to 5 years, as many as 5 years, before someone is removed from the rolls due to inactivity.
I can't give you an insight into why. There's no possible reason. This statute has been around for 30 years now. This is the 30th anniversary of this statute being adopted. It was part of the motor voter law. It provides
So that was passed during, the Clinton years.
administration, and it's called the motor voter law because it specified that you can register to vote at the Department of Motor Vehicles. But the other part of that bill was that while we will have more registrations at the Department of Motor Vehicles, we will take efforts to make sure that everyone who's on the roll is supposed to be there.
So that's the nice way of putting it. But Democrats wanted to pass the bill. Conservatives and Republicans objected because they thought everybody and their mother was going to be registered 2 or 3 times every time they showed up at a DMV or a welfare office or collected a check or had another interaction with the government. And supposedly the deal was, oh, don't worry, we'll require steps to clean up the rolls. Well, how did the law end up getting enforced practically once the left got what they wanted?
Well, there are 2 sets of people who can enforce the bill. One is private people like ourselves,
Right.
Who are aggrieved by violations of the law. The second group, really the first group, the one that you ought to go to first, is the Department of Justice. The Department of Justice is empowered to enforce this law in all the states where it applies. And it ought to be doing so, and it's not.
So how do you know about what the Justice Department did? It's not just observation from the outside, but you saw their approach on this from the inside.
I did. When I was at the Justice Department over a decade ago.
During the Obama administration.
Yes, and
part,
latter part of the George W. Bush administration and the Obama administration.
So you were a civil servant working in the Justice Department. Is that a fair way to put it?
Deputy chief of the voting section.
So
yes.
a career employee.
Right.
So you were apolitical in the way you did your job. You weren't, obviously you had to pay attention to the policies of the Justice Department as implemented by the political appointees, but you did your job without regard to party and candidacy.
Did. I absolutely did, but you gave me a start because politics had everything to do with how they enforced it at the Justice Department. I brought, in my tenure there, 5 cases under the motor voter integrity provisions, specifically aimed at list maintenance, okay? I brought the last one, it turns out, that the Justice Department ever brought. This was 2008 against Philadelphia. That was the last claim. Okay, now since I've come to Judicial Watch, I can't count. I mean, it must be more than 10 cases, right? More than 10 statewide.
Dozens of letters warning people and such.
Yeah.
So the other side of this is that, as you said, private parties can institute or initiate litigation under certain circumstances. And Judicial Watch was the first group to pursue litigation privately in this regard, right?
I wasn't here. I think it was.
Indiana and Ohio, 2 Republican-run states at the time. We sued because their roles were out of whack. This was in 2012.
Yeah,
And those cases ended or were settled because we essentially got what we wanted.
we did. We did. They removed a lot of voters. I mean, that often happens when we start these suits. They never come to fruition in terms of getting a judgment because the state throws in the towel and does what we're asking. That happens all the time.
But before
That's
I
how
get,
we get to 4 million registrations.
but just how awful, I want to get back to your Justice Department.
Sure.
How awful was it over there in terms of the politics and the contempt for the rule of law when it came to election integrity? I mean, you say you brought those 5 cases.
Yeah.
My guess is those cases weren't well received by your colleagues and your supervisors. Am I guessing correctly generally?
You are correct. And they were all started during the portion of my tenure that was in the George W. Bush administration. And they stopped cold in the Obama administration.
So the Obama administration initiated 0 cases to enforce the notion that states take reasonable steps to clean up the rolls.
That's correct.
And it's not because the rolls were clean and they were doing their job.
Oh, no. I wrote the internal memoranda saying that this state, and the other state are ripe for a lawsuit. So, no.
So we started doing our own analyses. Judicial Watch did, our experts, our lawyers, and then you later. When did you start at Judicial Watch? Remind me when you started.
2013.
So 10 years. 10 years. Wow.
That's right.
How quickly time flies.
It does. And we started, I actually couldn't participate in one of the lawsuits because I had sued the same state for the Department of Justice. So that's
Oh yeah, that's a classic story. That's when the Justice Department threatened to throw you in jail if you participated in a case, right?
I got some nasty letters. I can't claim to have been threatened with jail, but yes. You know, at the time the Obama administration's people came in, there was a famous meeting, and this meeting is, you know, not something I'm just remembering. This is written up in an Inspector General's report, and they talk very clearly about the events of this meeting. And I took notes of what was said, and someone else did too, and the notes say the same thing. There was the woman who was running the department.
An Obama appointee.
A political, as we call
right.
it, coming in to tell the career people what to do. And she said that she did not care to enforce the integrity provisions of the motor voter law. I don't care about that because it is not about increasing registrations, it's about removing them, you know, and the key phrase was don't care. And the people who were there and heard that took that to mean that this is no longer an enforcement priority. And that is how it worked out. Now, you know, there have been subsequent denials about, oh, I didn't mean we wouldn't enforce it. Well, how do you explain 15 years of non-enforcement?
And even during the Trump administration.
That's what they meant.
And even during the Trump administration, they were slow on that area. I mean there was
they were.
There was one case where they intervened in a case we had in Kentucky.
Yeah, Kentucky. We started it and they joined.
And they jumped in, but that was it.
Yeah, that was it. And, you know, I'll tell you, I can't give you precise numbers. There are, what, 3 or 4 million federal employees? And there are all these corners of the federal government.
And there were 10 Republicans and conservatives among those employees? Is that the way it worked?
And there were 3 in the voting section of the Civil Rights Division.
Out of how many attorneys?
There were 30 or more, 30 to 40.
So that was in a Democrat administration,
Yeah,
nominally apolitical career civil servants.
nominally.
You could tell you understood there to be only 3 conservatives or Republican leading employees.
When I left, by the time I left, yeah, I won't say I closed the door and put out the lights for the Republicans, but I was one of 2 or 3 remaining. The number of employees that had gotten as high as, maybe 6 or 7, maybe more during the Bush administration. But, you know, you were harassed. The Inspector General's report makes clear that hiring was funneled in a way that kept Republicans out of power, out of employment. And, you know, by now I would say the numbers are 100%. There's probably not a single Republican in the voting section of the Justice Department.
So what I loved about, well, I shouldn't say loved, what I thought was a very telling story was the story you told about how, as a senior official, you were nonetheless kept out of meetings, right? And then you complained about it, and they'd let you come to the meetings, and then how were the meetings run?
Yeah, well, I mean, the way I've described it is, it's as if I was wearing a wire, okay, which I wasn't, okay, for the record. They would talk to each other like they talk to each other on the movie Goodfellas.
We're going to do that thing.
We're going to do the thing. Oh, do you mean the one thing? No, the other thing.
And they wouldn't tell you what it was.
I would say, what are we talking about?
So they say, all right, Popper, you can come to our meetings, but we're going to speak in code so you don't know what we're doing.
Well, yeah, that was after a 3-4 month hiatus where they held meetings without me.
So that's just classic. Well,
yeah, but I mean, for me, that kind of stuff is petty and sometimes borderline crazy. What people will do to cut other people out. For me, the meat and potatoes of the enforcement of that law, the real indication that it's not enforced is that no cases have been brought in 15 years. And what I was saying was, if you're the Trump administration, presumably, and I believe you're more favorably inclined to pursue a case under the list maintenance provisions, you can't change all the personnel in the department to make them pursue it with vigor, to make them approve the memoranda requesting such lawsuits. You can't, you have to pick your fights, God knows. And the Civil Rights Division of the voting section was not a place where that statute came to be enforced, really, since I left.
What I think is interesting about the litigation, and so the long story short is that Judicial Watch initiated virtually all the major litigation that's resulted in voter roll cleanup in the last decade. The Justice Department has been, for all practical purposes, AWOL, and frankly has looked to Judicial Watch to do this to the degree they're even interested in it. But what's interesting is that the settlements, so you go to court and you fight, and it's one thing to go to trial. So most of our cases, when we pursue them, settle, right?
Right.
And they're not settled with, it's not where these leftists go in and sue their friends and they settle and they get a sweetheart settlement, kind of like Hunter's plea deal. We go in and sue California, Los Angeles County, New York City, extremely far left jurisdictions, and it says a lot about the power of our legal position that they settle with us. And in the case of California, I think the numbers are really, truly remarkable as to what we were able to accomplish through that settlement. And to the credit of California, rather than waste money, they just did the right thing legally, as we thought the law required.
They sent out 1.6 million notification letters. And, this takes patience. There's not instant gratification with these lawsuits. 2 general federal elections later, they duly removed, at the time there were 1.2 million registrants who never responded and who hadn't been removed in some previous tranche.
And that number was confirmed to us earlier this year, right?
Yes, it was.
So that's in California. In New York City, so California, I want to go back to California. They hadn't cleaned their rolls in 20 years.
Right. And see, this is part of the story too. There's always another part of the story that makes the government not look particularly good. But as soon as the motor voter law was passed, and as soon as the integrity provisions were included, the government, in the form then of the Janet Reno Justice Department, went to war against the NVRA, at least against the integrity provisions, and came up with this interpretation that it's not enough to send a letter and to wait 2 federal elections. You need secondhand, this is their phrase, secondhand reliable information to justify even sending the letter. Now, that's not in the statute.
What does that require, sending detectives out to find out where people move?
Ideally, I suppose. But under that interpretation, they gave California a pass.
It essentially freezes, because the agencies really can't get that secondhand credit.
Yeah, what does it mean?
That's difficult. That's difficult to achieve. Assuming it meant anything, it's a difficult hurdle.
Yes, and if you pass it one way, does that mean that some interest group is then going to sue and say, well, that's not reliable enough? And then you have fights over the word reliable, which are doubly difficult because the word doesn't appear in the statute.
So California,
it's made up.
So California said, oh, we were applying the law as Bill Clinton told us to apply it, but we agree we'll apply the law as Bob Popper is telling us to apply it.
Well, to be more blunt about what happened is Janet Reno made a deal with California, then with the Pete Wilson administration, and said, we will sue you, but we will drop our lawsuit if you agree not to enforce state law that enabled the NVRA, and they agreed, and they duly didn't enforce it for 20 years until we came along.
Now, so LA County has cleaned up of 1.2 million names.
Yeah.
The state, as part of the settlement agreement, has reminded other jurisdictions, the local counties, that they need to really take this seriously. Have the other counties? My perception is no, but I know you've been looking at the data recently. Have they gotten their act together?
No. And absolutely, emphatically not. There are counties that still are in the sort of 20-year limbo of, now 20-plus years of never having enforced the statute as it was meant to be enforced. And I did want to add, in 2018, the United States Supreme Court issued a ruling that rejected this whole reliable write-in to the statute that was never there in the first place, and just said, you can pick any reason you want to send a letter, and once you do and 2 general federal elections go by, these people must be removed. So that's what everyone who could read the statute as it was written always thought.
And you're too humble, because that was a validation, and an issue was the settlement that we had come to with Indiana. Ohio, excuse me.
Sure.
And the Supreme Court of the United States, the left didn't like the idea that the rolls would be cleaned in Ohio. Yeah. Or in an effective way. And the Supreme Court said, well, what Judicial Watch in Ohio came up with, and which we're applying in other states, that's right. And certainly that was a signal to states like California and New York City, which was also a mess, and they settled almost.
Tremendous help.
They settled almost. I wouldn't say immediately, but in terms of litation,
as close to immediately
it was like months after we filed, if I recall.
They removed 525,000 registrations that were due to be removed within months of our lawsuit, and we concluded a settlement agreement with them, and there was never any question there that it was our lawsuit that caused them to make these removals. Right. They told us that. Other states have fought that notion, even though we did cause them to.
Well, this is classic. You send the letter, right? There's a warning letter. You say, look, your rolls are out of whack. You file a lawsuit, and they immediately clean up, either tied to the letter they don't tell you or after the lawsuit. And then we're like, well, they cleaned the rolls. It looks like they got a system in place, so we're going to shut it down. And then they say, well, we're going to do that anyway. Well, the people can judge for themselves whether that would have happened or not. So New York City cleans up their rolls, so we get 1.2 million out of California this year. New York City's 450,000 or so.
525,000.
Oh, so it's even more than that now. Yeah. It's over 500,000. That's incredible. North Carolina, we sued.
Yeah, North Carolina fought hook. They tooth and nail the idea that we had caused them or incented them to remove anyone from the roll.
So they removed
430,000.
So 430.
It's you have to count it a different way, but one of the terms of our settlement was, we'll settle this, but you have to explain to us why there's been a spike in removals. And they sent us this tendentious, politically complex explanation as to why removals had been like this and then spiked once we sent them a letter. And it is not convincing, and there I would say that our intervention caused them to remove 400,000 to 500,000 registrations that would not have otherwise been removed in a timely way.
And sometimes, in Pennsylvania, we also had a settlement that removed, 300? I forget the number there.
178,000 to start with. And the fun thing there is that the state was responding to a brief of ours in court at a time when the case was still live before we settled. And the state said, listen, this is almost verbatim. I'm speaking colloquially, but they said, we got this letter from Judicial Watch identifying 25 counties that may have been behind. We went to those 25 counties and we worked hand in glove with them to remove as many registrations that needed removing as we could. And together, we in the 25 counties removed 178,000 registrations. And there are other counties we didn't name who also were removing registrations. We sent letters to more than 25 counties, and some of them would write back and say, oh, well, we hadn't been removing registrations. Now we are. The biggest example, which didn't end up being part of the lawsuit, was Allegheny County, which told us that they removed 69,000 registrations upon receiving our letter.
So our letter said your registrations are out of whack, and they said, you're right, we're going to remove all these names.
Yeah, by the way, all these letters, they don't just say your registrations are out of whack. They say your registrations are out of whack, and we're going to sue you under the National Voter Registration.
Right. It is.
So it's a little more incentive.
It isn't an FYI. It's do this. You need the.
But yes. And so Allegheny County.
But in the case of Allegheny,
70,000.
the threat worked. You're saying, look, there's an issue here, and that's what. And to be fair to New York City and North Carolina,
hats off to New York City.
We're always pleased when they settle. So
Yes.
and by settling, they're not admitting they did anything wrong. To be fair to them, but the numbers are what they are. Colorado similarly settled.
Yes. Well, New York did sort of admit that they weren't doing what they should have been doing.
Right.
But Colorado settled. There's some controversy about what exactly did happen there, but they do seem to have improved,
Cleaned up.
And the statute says you can only sue if someone is not taking reasonable steps. And unfortunately, in my opinion, the statute doesn't say you got to remove 50%. It doesn't put a hard number on removals. It says it has to be reasonable, and reasonable. Any child. Asking for more ice cream can argue what's reasonable.
So so when you're doing your analysis, you get records that they tell the government how many people are registered or inactive, people who have been voting for a while, and then you kind of look at what their populations are, of eligible populations who, in theory, can vote. And so, unless you've changed your analysis, one thing that kind of triggers you is saying, wait, they got more people registered to vote than are actually living there and eligible.
Yes.
And that's probably a good indication they're not cleaning up their rolls.
Yes, and another pet peeve I'd like to address, if I could, is that when you're on the inactive list and you're waiting to be removed after 2 general federal elections, if you show up during that time period and vote, no problem. You can vote. So in my view, those inactive registrations are live registrations.
Until your name is removed from the rolls, you can vote.
If you can vote it, it's a registration.
And that's why the law frowns upon not taking steps to clean up the rolls, because that's obviously an invitation for fraud. Does it mean there will be fraud? No, but it's an opportunity for fraud, and the line I use is that dirty election rolls can mean dirty elections, and that's why that's the only reason the law is out there, because otherwise no one would care if the rolls had a bunch of extra names there. It's a pool from which fraudsters can draw to vote in other people's names, or more than once, or however you want to tame it.
And to be fair to the states, there used to be state laws governing all of this, and this was all federalized with the National Voter Registration Act. Good idea, bad idea, who knows, but it's what we have now and have to live with.
So some states enforce their own state laws to clean up the rolls, like in Wisconsin. They did that recently, I think under litigation, if I recall.
Wisconsin is exempt from the National Voter Registration Act. There are 6 states that are exempt, and don't ask me to rattle them off. But
Wisconsin and Oregon.
Wisconsin, New Hampshire.
One of those Northwest states. Yeah. I know you're all going to think,
something or other.
Boy, that East Coaster, he doesn't know anything about the West Coast, but out that way, one of the states is exempt.
Yeah, but just to get back to the point about, you can still vote these registrations. 5 federal courts have found that when you're counting voter registrations and you're trying to see if you have greater than 100% registration, you count these waitlisted votes. Okay? No court has ever held otherwise. And you go to these fact checkers, and they say that we are not saying correctly what the voter registration rate is because we're counting the inactives. Excuse me. We and 5 federal judges are counting the inactives, and we're counting them for a logical reason, which is that those registrations can still be voted. So, who's going to Snopes the Snopes people?
Yeah, well, the fact checkers are left-wing advocates and often partisan, and the left hates us doing this. It's one thing to go into court and have to face government lawyers, well-funded, obviously. There's infinite resources. But our cases often aren't just limited to state and government actors, but the left tries to interfere with or engage in our litigation as well. Can you talk about that a little bit?
Well, as I was saying, they're at war with this statute. They don't like the list maintenance provision. They tried to hamstring it from the outset. They succeeded for decades.
By non-enforcement.
And also by a messed up interpretation of what the statute says or actually doesn't say, that only recently was, finally rejected by the Supreme Court. But it's almost like when you're in my position, you talk about the media, you talk about the fact that one of their greatest powers is simply not to report certain subjects. Well, one of the greatest powers of the Justice Department is simply not to bring certain cases. Okay? For me, the biggest delinquency in terms of enforcing the National Voter Registration Act by the federal government is bringing no cases in the past 15 years under that provision. Lawsuits are brought under other provisions requiring, enforcing the removal requirements and saying you can't remove this person or you can't use this data. The other lawsuits that increase the number of people who are on the voter rolls. But lawsuits to remove people who moved to other states, there have been none, zero. And that is probably the most significant way in which the Justice Department has made war on this statute. They have 30 to 40 lawyers. Okay, we have 3 voting dedicated lawyers at Judicial Watch and a consultant. If we had their resources, we could bring these suits all over the country. There would never be an issue anymore of enforcing the NVRA. But as it turns out, we and perhaps 2 other outfits, but we in the lead, are bringing these cases. This is, for all practical purposes, the NVRA is our statute because it sure isn't the government's.
Well, it's a remarkable testament to not only your excellent legal skills and that of those of your colleagues, but to Judicial Watch generally, that millions of names have been removed or are set to be removed from the voting rolls thanks to this little old nonprofit here in Washington, D.C. And,
we are the People's Justice Department.
Certainly in this area, and it's more important than ever given, I think, the crazed rush to throw out millions of ballots into the mails. The least you can do is make sure that people are at the place that you're mailing the ballots to before you send them out or invite them to vote or register or whatever else they're doing. It's outrageous.
Right.
But this isn't the only thing we do at Judicial Watch. It's related to election law. Another big issue, and a significant one, where an issue where we've had a significant impact, is the issue of gerrymandering, which may be a word that people aren't necessarily familiar with, but every 10 years, the Constitution allows the states to reapportion congressional districts. So if you live in a congressional district, you may be moved into another, depending on how the district maps are drawn. And of course, the political classes have a very keen interest in making sure that if you're a Democrat, you want as many Democrats in as many districts as you can get away with, and similarly for Republicans. And what's been Judicial Watch's role in trying to police this? What laws restrict the ability of the politicians to manipulate these maps? And I know that's kind of a big question, and it's one that still has some unanswered questions in terms of what the law will require in the future. But what's been our role there?
A big role. There used to be a federal law, and I believe it was repealed in the 20s sometime, requiring compact congressional districts.
So what do you mean by compact?
You could just say visually compact, but there are mathematical measures, including the Polsby-Popper compactness measure.
So this is how much of an election nerd Bob is. Bob has a methodology of analyzing whether congressional districts are reasonable or not using a mathematical formula that he and a former colleague came up with, and it's actually used in these various cases. So you get to cite your own mathematical formula in your own litigation.
And
that must be fun. It's a
it
little
is,
meta,
but
isn't it?
I realize that the lawyers never realize that I'm the papa.
So the Popper formula,
Yeah,
you're the Einstein of gerrymandering.
No, because we tried to take this formula, and your first question was, where's the law saying you can't do this? Well, there used to be a federal law that was repealed decades ago, century ago. And then there were a lot of arguments, and we made them, that the federal Constitution requires, if you're going to require equal population, the other side of that has to be compact non-gerrymandered districts. The Supreme Court of the United States did not go for it.
So if you're
in
looking,
2016, this was our Maryland lawsuit.
so if you're looking at your typical state, let's say a flyover state, right? The square states, and they've got the counties. They're usually square. You're supposed to look at that. You're supposed to look at that state's map and say, okay, well, this district is that county. The next district is the other county. Well, we don't have, we've got not enough people in this county, so we're going to put two counties together. But generally speaking, a community is part of the district as opposed to what is happening too often where, let's say, you're in the state of Florida, and I'm not saying this happens in Florida.
It happens in Florida.
But where you have a district that begins in Miami and ends in Tallahassee. Now, I exaggerate, but obviously that doesn't seem normal or right. But the question is it illegal?
To the extent that it's illegal, if it's not under the federal Constitution, the argument has to be made under state constitutions or state law. And there you can get some traction and some results. We got a result in Maryland under the Maryland state constitution. Other persons have gotten results. The one in New York is now up for appeal, but they did get a result that it was an unconstitutional gerrymander.
Based on our win in Maryland, if I recall.
It referred to it, yes.
So what happened in Maryland was the Democrats who controlled the legislature, and I don't like to be partisan, but that's the reality, is they control the legislature, and they get to draw the map, and they drew a map. There were, I think, 2 majority Republican congressional districts when they began. At the end of the process, there'd be half of a one that was barely a Republican majority, and the other was completely a Democrat majority.
Yes, and I mean you have districts crossing over bridges.
Right.
I mean you had some ludicrous-looking districts. One was described as a broken wing by a federal judge, a broken-winged pterodactyl. So
you challenged that, or we challenged that on behalf of candidates and voters in state court. And, we got it's Maryland, so we did not get a conservative judge by any means. But this judge was pretty sharp, and she saw right through this political
Yes,
game.
and that's a national trend. I think that these state judges, one of the things the Supreme Court did when it said there's no federal claim here, is it said, now, of course, there could be claims under state law. And so everyone rushed out to their state courts, and that's where the fight is now, and we're part of that fight. But
now, of course, that now the other side of that debate from some of our conservative friends is that, well, the legislatures have categorical rights, it would seem, under the Constitution to draw maps. And, of course, politics are going to get involved, and, of course, Democrats are going to try to rig it for Democrats, and Republicans do the same when they're in power. And if you don't like it, vote out the legislature for the next time the census emerges. What's your response to that?
Well, what the Supreme Court said about one person, one vote applies to that. And what it said is this is one of those situations where you can't vote the bums out because the bums can protect themselves. What gerrymandering does is it allows legislators to effectively elect other legislators. Or put a different way, it allows candidates to win elections without having to convince anyone to vote for them.
One might
what
say
they ought to be doing.
One might say it's election rigging in terms of guaranteeing a partisan result.
It is clearly cheating. You're
Yeah.
not convincing anyone to vote for you.
So what was troubling last Supreme Court term is that obviously there's this kind of state consensus building around that political manipulation based on partisan affiliations not appropriate. Having crazy maps that kind of have someone in New York City have the same congressman as someone in Buffalo.
Yeah.
But the Supreme Court seems to suggest you could sort voters by race any way you want to get the politically correct result. Am I unfairly characterizing the Supreme Court's terrible decision in that regard?
You're simplifying it, but that's the essence of it. Listen, there was a decision in 1986 that read the Voting Rights Act to permit a remedy of a racially drawn district. And how far you can take that racial redrawing has been cabined, among other things, by a lawsuit I brought in New York in 1995. You have to cleave to traditional districting criteria. The district cannot be too non-compact, and one way to measure it is with the measures we use. But you still are permitted, and in certain circumstances under Section 2 of the Voting Rights Act, you are required to draw such a district. Now, that area of the law is troubled, but there was a recent Supreme Court decision that upheld in so many words what was decided in 1986.
And that was how close, that decision? Do you recall? Was that 5-4 or 6-3?
It was 5-4. I believe that Justice Roberts concurred with the liberal wing and Justice Kavanaugh. And it was Kavanaugh who suggested other ways in which there might be a challenge brought to that practice. I personally think that drawing districts on the basis of race is not a good idea any more than drawing it on the basis of any other characteristic of the population. Districts should be drawn as neutrally as possible and represent communities. How you make that happen is with one person, one vote, and compactness.
I mean, but just think, and who loses?
But who listens to me?
Well, and I think people should listen to you, and people of good faith should listen to you, because just think about it like this. So, Black Americans tend to vote overwhelmingly Democrat, right? So, there is a value in having them in districts where Democrats are likely to succeed. But you also want to have them spread out in a way so that more Democrats can benefit from their voting power. And if you're a Republican, they see Black Americans as Democrat voters, so they're happy to see them in other districts. And so they get, so their power is necessarily dissipated. It's not, if it was naturally in one jurisdiction or one district, they would be able to get a candidate more in tune with their values, not just, quote, a Democrat, but a Democrat who is more in tune with Black Americans. And if they were in numbers where they might otherwise be in a normal district, in a Republican district, you would have Republicans paying attention to their political values in a more direct way. So they're treating Black Americans terribly and dissipating their power while pretending to be concerned about discrimination.
Yes, and this has been noticed now for years. It was discussed a lot by Abigail Thernstrom. I mean, the idea is that Republicans, who are now, I think on principle, should be opposed to racial districting, now favor it because it allows the lawful concentration of core Democratic voters in a way that frees up Republicans to run in their districts without as many worries. And I think it radicalizes, on a larger sense, radicalizes both parties and allows people to succeed who don't have to try to appeal to other voters who are residually left in their districts. I don't think it's a good idea for that reason. And the Democrats have noticed this too. One of the untold stories of the past several years is that when Section 5 of the Voting Rights Act was struck down, which was another provision that in certain circumstances required racial districting, the lawsuits pressed to undo those racial districts that were drawn to favor Black populations and to concentrate Black voters. The lawsuits were brought by Democrats. And this is, if we had an honest news media, this would be a story that people would know more about.
Well, let me be blunt if I could be. There's segregation in America, and at the federal level, the Supreme Court has endorsed segregation of voters by race in congressional district, in congressional districting. Am I correct? That you can, it doesn't mean people are forced to move somewhere, but the voters are forced into districts based on race. And if that's not segregation, I don't know what is. And I reject it, and anyone who supports it should be called out for their racialism.
Well, I reject it as well, but when I came close to suggesting this to, for example, the Florida legislature, there were massive objections to this. And this is why something of a political settlement
because the Republicans wanted to have
they wanted to gerrymander.
Yeah, they wanted black Americans in one district.
Yes.
And that was and then they'd have all the other districts for Republican-leaning voters.
And listen, I mean, can you blame the Republicans for doing that? Okay, if they don't create a black majority district, they might be called racist. They will be called racist, and it's all a game. None of it's sincere. All of it's disingenuous, and it is a stain on how we do politics. And one day we won't have it anymore.
So the way to end race discrimination is to end race discrimination.
Right.
Let's just stop it.
Well, let's hope that the Supreme Court justices who say such clever things abide by them.
That's true. So the Supreme Court justice who said that was Chief Justice Roberts, who in ending that Fisher case, or ending racial discrimination in college admissions, previously endorsed racial discrimination in voting cases, and at least in congressional districting. But let's talk about that issue, because that was another. Okay, there's racialism in our electoral system that we think is inappropriate, and then of course there's state-sanctioned racialism in other parts of our society, nominally to address racism, but engage in doing so they actually are engaging in racism. And the Supreme Court had a major decision related to college admissions this last term. I guess there were two decisions, one about the University of North Carolina and Harvard admissions, and they basically said you can't take race into account when admitting someone to college.
Yes, and we submitted amicus briefs at all stages of that appellate process.
I mean, that was almost a 10-year appellate process that finally got that result. More or less, if you consider
more than that.
other.
If you take it back to Bakke in 1978, and then the Grutter decision, and then
so those were two earlier Supreme Court decisions
right.
that had endorsed racism in college admissions.
Endorsed. I mean, we identified something like 5 Supreme Court cases. We identified something like 26 opinions, if I'm quoting it accurately. They were so fractured, and there were so many. There was only a plurality decision in Bakke, for example. The jurisprudence was a failed jurisprudence that was so convoluted and difficult to apply that there never really was one opinion about why it was okay and how it would be done to make it okay. Well, now that is no longer the case. And of course, colleges are scrambling to do what? To continue what they always did, or what they did until recently, and to admit people on the basis of race, and to take race and make it a determining factor. There was a good Wall Street Journal article recently about this that suggested the way they're going is to seize on some language in the decision and try to evoke in essay responses some sort of indication about your race.
So they want to.
So then you could use that and say, well, we're using this as a measure of this person's, I don't know what, worldly education. I don't know if they can use the word diversity anymore. Anyway, it's more disingenuous games.
But it was a significant decision in the sense that it kind of lays the groundwork for deeming, in my view, unconstitutional other race conscious, as the word is used, but it's racially discriminatory hiring practices in government,
Absolutely,
contracting.
Yes.
The left talks about systemic racism, and the only systemic racism is promoted by left-wing bureaucrats and politicians who know better or should know better, and corporate HR people and corporate heads who specifically hire and fire and disperse benefits based on race. That's the systemic racism. It's racial discrimination for one group, in this case African Americans, against other minorities typically. I mean, the best example of this is President Biden and the irony of this justice then opining on these topics is high and rich. But Justice Jackson, President Biden said, I am going to limit my choices to a black woman for the Supreme Court. And it's outrageous. I think it's unconstitutional and anti-constitutional in the least. But what that meant was that a male who was black couldn't get through the White House front door to get it considered. A female Indian American or a female Asian couldn't get past the front door. So not only are, quote, whites discriminated against in these racialist programs, but other minorities as well. And we've seen that with this big local high school. If you're not in DC, you may not know the high school, but anyone in the DC area knows about, just think of the best science high school in your hometown. And this is the DC version of it. You talk about this case because it doesn't cut along, it cuts along some of the lines we've talked about, and it shows the dishonesty behind this racialism.
Thomas Jefferson in Virginia, and the case is called Coalition for Thomas Jefferson, Coalition for TJ. It's a high school that admitted on the basis of merit, and it was very selective, and it ended up admitting 74% Asian applicants. And what the high school did was say, well, we're going to alter how we induce people to apply, and we're going to go to individual high schools or institutions, schools around the region, and we're going to get them to, we're going to take, I think, the top several percent, top 10% of those classes, and we're going to do this regionally. And the reason to do it regionally, as everyone understood, the real reason was to change the makeup of the school. And it succeeded. It went from 74% Asian admittees to 54%. And there are emails, there's a trail. There's evidence saying that the reason this was done was in order to effect racial balancing, and that's not constitutional. I am concerned that what people will do is learn to hide their conversations, learn to make phone calls instead of send emails, learn to be disingenuous in a better and more effective way in the future. But this is one attempt to get around restrictions on how people are admitted based on race.
What was the problem that was being addressed when there were 75% of the school was Asians based on merit?
I don't know what to say.
Other than racialism.
Too Asian?
Too Asian. So it was anti-Asian animus.
Could it be anything else? But
the argument is,
yes.
And the argument from the left, to give them the credit of their argument, say there's a public interest in diversity. This is a public high school. It's supposed to be, available to all students of all backgrounds, and we've got this system in place, and we're not anti-Asian per se, but we don't mean to just have only one ethnicity, practically speaking, represented. Now, that might be a reasonable position, but it almost always results in punishing people based on race and giving benefits to people based on race, which I thought we're not allowed to do. And so, didn't the Supreme Court tell us that diversity was not a reason to engage in race discrimination?
It did. Listen, this country's regrettable race history has led to the development of a jurisprudence at all levels of courts, but at Supreme Court especially, that sees beyond fake excuses and pretexts and gets to the heart of the matter. And the heart of the matter is, you say you're doing this. What you're really doing is based on race. The classic case, certainly in American history, is Yickwo v. Hopkins, where there was a rule that laundromats had to be made of brick. Well, the wooden laundromats were Chinese, okay? And the idea was a trade barrier against Chinese laundromats.
And everyone saw through it.
And they saw through it, and nothing in Supreme Court jurisprudence, I think, is as well developed as its ability to detect pretext, race hiding as pretext. And so the university officials and the school officials who are trying to get around this, I believe, are going to run into just a bristling hedgerow that they're not going to be able to get through. I mean, this has already been determined, how to tell when someone is making something up. I think of the Coalition for TJ analysis. Well, what's the simple thing to do? It's to look at the 74% and compare it to the 52%. It's to look at what people say, but even if you don't have people admitting on the record what they're actually doing, it looks like they're trying to reduce the number of Asian applicants. Its timing suggests that it was in response to national events that raised the issue of race.
This is around the Floyd death and the riots, right?
And Supreme Court jurisprudence is not stupid and sees through that kind of thing. It did so admirably in the 50s, 60s, and 70s, and it will do so now.
My concern is in recent years the veil has been lifted by, the left used to be supposedly concerned about racial discrimination, and they simply believe in it now. And it used to be they tried to kind of mask it in diversity and such, and it's now a racial spoil system. They're blunt about it. They want quotas. They embrace quotas. They used to run away from that. And I think that's one of the reasons they hate the Supreme Court and they're trying to destroy it as much as they are, because the Supreme Court could be this initial decision. I think other decisions following that could be the death knell for this racialism if the court keeps on going the way they are. And that's why they particularly hate Clarence Thomas, the black conservative, who not only sees through this in a legal way, but as an older black American who suffered actual discrimination and saw how so-called affirmative action harmed the black community, he's bearing witness in a way that's devastating to them.
Yeah.
So this is a major issue. It's a major issue for Judicial Watch. When you think of critical race theory, this is what we're talking about. Just allowing racism to have this veneer of legalism around it, using code words like diversity and equity and things such as that.
Or could we call them dog whistles?
Dog whistles is the other phrase.
But listen, for me, exactly what you're talking about, it's correct, but it is epitomized in two developments. Colorblind is now a dirty word. I mean, I used to...
The critical race theorists say that if you're colorblind, that's racist.
That's right. And equality is a dirty word.
Yeah, because that's racist as well, because it cements in the inequality and inequity that's been set up by the systemic racism of the United States.
Equity is code word for preferences.
Yeah, yeah. So, it strikes me as you talk that Judicial Watch is America's leading civil rights organization. And it's ironic, or I don't know if ironic is the right word, because I think we've always been in favor of civil rights applied properly, is that when it comes to race and voting and your rights under law and your right to be treated according to the way the Constitution demands you be treated by government, whether it be protecting you from being punished for exercising your First Amendment speech, or defending your rights as a voter, and in terms of being able to vote for a candidate that isn't taken away from you through illegal means like gerrymandering, as we're talking about. There's no one doing the civil rights work like we're doing, and certainly, obviously, trying to vindicate the core aspect of the 14th Amendment, which is, equal justice under the law. I talked about the First Amendment. I want to talk about the current crisis with the indictments of Donald Trump and other Americans over their efforts to dispute the 2020 election. Now, you're an election lawyer. and a national expert on election law, and you've kind of been around a lot of elections, you've monitored elections and such. Did you ever, in your wildest imagination, think that a dispute over alternative electors and electoral counts and how to manage the 12th Amendment and the Electoral College Act and yelling about voter fraud or structural infirmities in the way an election was run would result in you being prosecuted by the federal government?
No, I never did. I'm no expert in criminal law, but I think that these claims have major problems and intrude on First Amendment statements, and there are things that we're allowed to say, and I don't see how they can be criminalized. Even if you could bring a claim that could hang together technically, it's contrary to the spirit of our political system to prosecute someone for ambiguous statements that they make in a political arena, someone who got 70 million votes. So I didn't think that this would happen.
Well, you're a civil rights lawyer. You're in the Civil Rights Division of the Justice Department, and there's a dispute in a state like Alabama, and a group of African Americans, after an election outcome, demand recounts, demand audits, suggest that there's fraud, and in response, the Alabama local county prosecutor prosecutes them for trying to thwart the lawful outcome of an election. As a civil rights lawyer in the Justice Department, and knowing the way things have worked previously there, wouldn't that be enough to trigger a federal civil rights investigation into these state officials punishing people for freely exercising their civil rights based on race and other inappropriate and unlawful reasons?
Yes, you would think so.
I guess that's a loaded question.
Well,
but I mean, that highlights the absurdity we're in.
I'm thinking of Stacey Abrams.
Right, who did exactly what I'm talking about.
Yes.
But she was never prosecuted. And I'm not suggesting she should be prosecuted.
She still thinks she's won that election.
I mean, she's making a policy argument, arguing a rhetorical point, making a moral argument, a factual argument that we can argue about. Mm-hmm. And obviously government officials have to respond to from time to time. But the idea that complaining about and petitioning your government would result in you getting arrested, to me, is an abomination under law. And just so everyone knows, we're investigating what's been going on here. We have FOIAs in Georgia to figure out if there's been any collusion improperly with the Justice Department to see what was going on. But these are dark times for those of us concerned about election security and integrity, because the thinking is, well, what's the ceiling on this? Is there anything that can't be construed as illegally conspiring against the lawful outcome of an election if you challenge the lawful outcome of an election? Well,
I learned actually a lot about this from you, and I'll throw some quotes back at you. You called it lawfare, and that's what it is. And you also say that the process is the punishment, which is, regardless of the outcome. Tom DeLay had to devote how much of his life to fighting off those charges, and ultimate victory down the road doesn't keep you in Congress, and doesn't keep your position in Congress. To use the government as a hammer to hit your opponents is terribly wrong. And I'll give you a quote, which is, I think there was a South American official who said, "For my friends, everything. For my enemies, the law."
Right.
And to use law as a way to beat people up is a terrible precedent. And I have to say that the Democrats are better at this. Use this more often, do this more often, and do it effectively than the Republicans do. And I'm not saying I want the Republicans to get into this space. No one should be in this space. But, I can't help but think we're seeing examples of lawfare all the time. You can pick them out of the headlines.
So I don't know if you've studied this issue, but we had litigation in California where California started to try to change the requirements to be president, to be on the ballot. And we were successful in that regard. And the left, not happy with having arrested President Trump 4 or 5 times, is thinking of ways to keep him off the ballot by alleging he's an insurrectionist, even though there have been no court findings to that effect. I'm sure you've been watching the news the way we have, and I don't know if you've done any legal research. But what's your what's your impression of this argument?
I don't see how that can possibly fly.
Yeah.
I mean, without process, without procedure, I mean, that appears to be what they're contending.
So a state secretary, I mean, the theory would be a Secretary of State could
effectively has plenary power. Let me ask you something.
Say someone is an insurrectionist and keep them off the ballot?
Chuck Schumer said, he threatened the Supreme Court justices by saying that if they make certain decisions, they'll reap the whirlwind. Okay? And, this was perceived by a lot of people as threatening the membership of the Supreme Court, and he took a lot of criticism for it.
Is that insurrection?
Yeah. Could someone say that Chuck Schumer, if he, could not decide to run on the ballot in their state because he is an insurrectionist, if he should ever go for higher office, or if his own state, for some unforeseeable reason, ever decided that it could bring this sort of a claim and bar him from the ballot? I mean, it just seems wrong. Electoral decisions overwhelmingly should be made by the electorate. That's the impetus behind our gerrymandering claims and what we do there. And let the people decide. It's only in those cases where the system is so rigged they can't decide that you need another avenue. But this isn't one of those cases. If they believe that anyone is an insurrectionist, they are free to prevent them from holding any office.
Through lawful means such as like
voting
them out, right?
Yeah.
So what next? So we've covered gerrymandering, election integrity. And the other big issue is, before we go, I want to cover this issue because a lot of the 2020 election disputes were over the counting of ballots, and people were concerned, we have an election day, and they didn't figure out who won for weeks afterwards, or days, depending on the state. And I would argue that's contradictory to federal law, certainly at the presidential level, and arguably it's contradictory to congressional law if there's a congressional race involved. So we didn't just make that argument in theory, we went to court over that in Illinois. Could you describe that case to our viewers? Because I think it's an important one because it addresses something that is of great concern.
And we may go to court again. But I mean, what we've done is we started a lawsuit in Illinois where we said that federal law provides that an election day is the cutoff for election officials to receive ballots. They have to receive ballots by election day. And you're not receiving a ballot if you just put it in the U.S. mail. Those aren't election officials.
So going on election day and dropping your ballot in the mail ain't going to get it there in time.
Yeah, I mean, the question, and they're intersecting laws, and so it's hard to describe. But here's a simple way to look at it. You take a ballot home, a mail-in ballot. When it's sitting on your kitchen table, it is not a cast ballot. It has not been received by election officials. You fill it out, you're walking down the street with, it's not a ballot. You put it in a U.S. mailbox. It's not a ballot. It's being handled by the Postal Service. Okay, it is a ballot that needs to be counted when it's received by an election official, and it needs to be received by Election Day. And there's 2 federal laws that we believe mandate that result. And what a number of states have done is say that if they receive a ballot anytime up to 2 weeks after Election Day.
Specifically Illinois, that's the law.
Illinois, it's the law in a couple of states. They extend that deadline. If that's the case, then those ballots are counted even though they weren't received by an election official for all that time.
Even if they're not postmarked, my understanding is. They don't even need a postmark.
Yes, those statutes typically do say that.
What's the problem if they were mailed generally? What's the I mean, I say that, because you think it's obvious, but maybe it's not obvious. Why is that an issue? Generally speaking, people are voting, they're dropping stuff in the mail. Why not count the ballots?
Well, I'll start at a place that maybe a lot of people wouldn't start, but I know you started this place. This is what the law says.
Right.
Okay. That matters to me. That's not,
I hear you.
It's not an 8th grade, debate society where we can say, sure, that's what the law says, but here's what we want.
So you can't make up your own rules.
No, you can't. But also, it has been a degradation of the electoral system to have Election Day extended and extended and extended. People are not voting about the same thing. If the issues at this point in time are different than the issues at this point in time, you run risks. You run risks if you don't have to have a postmark.
Well, I mean, let's make it. Let's say someone is perfectly compliant with the law. Yeah. Polls close at 7 p.m. in Illinois, or whatever the jurisdiction, the actual time is, and the announcement is Congressman Bost is winning by 10 points, and he's our client in this case, and where it's very close. And there's someone in the district who hasn't voted yet. So, well, I'm going to vote for him, or I'm going to vote against him. And I'm going to vote after the polls are closed. I know what the results are, practically speaking, and I'm going to impact those results by voting late, in essence, right, we would allege. And that vote, and you mail on that day. You go to the post office at 8 o'clock, the 24-hour post office. Usually there's some place around that takes mail. And you've got a leg up on all the suckers who voted on time. That's why it's illegal, or at least that's why there's the law there. And I recall Supreme Court justices even in the last 2 years said, well, counting ballots after Election Day undermines confidence in the elections, because people just assume that's just the temptation for fraud, and to change the results as ascertained on Election Day is so strong that you're tempting a drunk in a bar. Am I fairly characterizing it?
That's true. Although I have to say, the first thing I said again, which is that's not we're not suing and saying that any Illinois election was decided wrongly because there was fraud.
Right.
We're saying that federal law says you got to do it this way. Federal law could say differently, but it doesn't. And that's
and if you're not following the rules, that's a part of fraud too. And people have a right to expect that the rules are followed. And if someone cheats, then why you
gave
should
a very good description of why someone might cheat.
You should presume that something is untoward is happening, and you can't have confidence in the outcome.
Yeah, it needs to be under the rules. As you say, elections should be clean. They just, should be. I mean, it drives me crazy when people say there are few instances of fraud, so therefore we don't need protections against it. No, elections are where you need the protections. And one example I like to use to compare that is that there may be a couple hundred securities law violations that are pursued in the courts each year. A couple hundred. There are billions of securities transactions. Do we need our securities laws? Of course we do. In the same line of thinking, of course we need our election laws.
Yeah, there aren't that many bank robberies compared to the number of banks, but you don't want banks to be robbed by suggesting it's okay to do so, because it's really no big deal, even if because the numbers aren't all that great. It's just, let me, again, I'll be blunt in a way that you sometimes are less comfortable than being the careful lawyer.
I feel like I've been pretty blunt, but go ahead.
The left wants to be able to steal elections. That's why they want to be able to count votes forever and a day after Election Day. That's why they hate the idea of cleaning election rolls. That's why they oppose voter ID. We didn't even get into that. And all these other sane security measures that are supported, I would submit, by 70, 80% of the public. Why would you oppose?
Poll after poll.
Yeah, I mean, so stop pretending that it's anything other than you want to be able to steal elections when necessary. That's my view. So before we go, what next? I guess we're looking at states to see their rolls, if their rolls are being cleaned.
Oh, we're in it. We've sent letters to 14 states inquiring about things that we noticed in the last federal report.
So we're being nice, huh? We're saying well, there's an issue here. We're not going to sue just yet, but give us some details here so we can figure out what's happening.
As my mother says, you're either right all the time or you're nice. So we're being nice. But I mean, there's also this practical
sometimes
reason.
the numbers are wrong for innocent
reasons. We sued
in
Pennsylvania, by the way. We sued after begging them to tell us what the numbers were, and they blew us off. But when we sued, some of the counties said, oh, well, these numbers are totally the numbers we certified to the Election Assistance Commission in Washington were incorrect by a factor of several thousand.
And Judicial Watch, you were terrible for relying on the numbers we gave to them.
That goes without saying.
Yeah. So we're looking at these states, so we're prepared to clean up the rolls over the next year or so.
We are. Where the NVRA is concerned, it's hunting season again.
Yeah.
We have a new report from the federal government that describes what states have been doing in the past 2 years based, as I said, on their own representations. And we've looked at that and processed it, and we have inquiries out. And if our inquiries are not satisfied in the way that makes us happy, we'll get more serious, which includes lawsuits.
So we've been doing these cases for 10 years, some of which have gained significant national notice, certainly within the election community, we're well known. Have the rolls gotten cleaner? Have we noticed that people are more sensitive to this, even in places where previously they were disasters?
I would say yes. I mean, it's impossible to know what effect you're having when you send a threatening letter and then you get no response, or you get an ambiguous response, and then you see that the rolls have been cleaned up. I mean, what happened there? And we do know through some of our FOIA work that, in fact, when a letter is received from Judicial Watch, there is an awful lot of attention paid to it and a lot of running around. What are we going to do? How are we going to fix this? How are we going to approach it? So we do have that effect. I say this with some, frankly, amazement, because that used to happen at DOJ, right? The Department of Justice comes knocking, people sit up and pay attention. And people would consensually take the steps that the Department of Justice thought they should take because they were concerned about potential legal action.
And we're doing what the Justice...
We're getting
we are the Justice Department in that regard. Yeah.
We're getting that reaction, and it's a good reaction. It means that we can punch above our weight.
So how many voter registrations? I'm not putting you under oath. How many voter registrations are there in the country?
Oh. I don't know, but...
150 million maybe?
Oh, more. 200?
200. And what, I've seen numbers...
Don't hold me to this. I don't know. Experts out there, I don't know.
What percentage of the voter registrations currently on file would you think need to be cleaned up?
Well, the typical inactive list for a state is about 10% of their voter rolls. So when you hit a state where 1/6 of their registrations, 1/5 of their registrations, sometimes more, are inactive, you're probably looking at a problem.
So maybe 20 million names need to be cleaned up over time?
Yeah, but I mean, to be fair, some of them might be legitimately in the NVRA's drawn-out process.
Right, that 5-year process, yeah.
Yeah.
Well, the point is you need someone who's diligent and in doing this and committed to this process. And if the process is ongoing, then there'll be names that are getting old, but they age out after a period of time.
Yeah.
And you viewers, this NVRA we're talking about, under law, as a citizen, you can ask your local jurisdiction, your state jurisdiction, for access to documents about the cleaning up of rolls, and they're supposed to give you access to those documents. So look that up online, and I encourage you to follow up on our website at judicialwatch.org to find out about all these cases we're talking about. Send us emails if you have specific questions. Bob will answer them personally.
I'll try.
And I encourage you to share this information, because the left has hijacked discussions on election integrity. They like to pretend everything's perfect. Our country's a lot better off than other countries, but it's really antiquated in terms of voter list maintenance and voter ID and other basic election security measures that would never be tolerated in countries that are supposedly backwards, let alone countries like the United States that have a commitment to the rule of law and election integrity as we allegedly do. And I'm proud to be working with you, Bob. You've been doing some great work. And as you can see, this is why Judicial Watch, because of folks like Bob, is America's leading expert on election integrity. You've testified to Congress a half a dozen times. You testified to state legislators, and our colleagues as well. So there are no better experts, I think, on either side of the aisle than Judicial Watch when it comes to some of these election fight issues. So thank you for joining us, and I encourage you to share this video and get the word out about this great work. And more is coming. We'll see you here next time. Thank you.